participants of the JCJ AP 2023, you are welcome. Karibu sana in Kiswahili. I read what I posted on the screen so that I could know them. You are with me, I am with you. Both are traveling the same boat to reach to the destination. Read what I posted on the screen.
Welcome to the aspirants of AP-JCJ 2023-ST. Timings 9 p.m. to 9:50 p.m. Civil rules of practice and circular orders in Andhra Pradesh, Telangana as amended up to date. Monday, 2nd January 2023. Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Mwanza, Tanzania, East Africa. Mobile number 919701440939.
Thank you very much. Now, without wasting the time, let me go to our study. That is the today's MCQ. Yes, once again, welcome to the participants for the Andhra Pradesh Junior Civil Jet 2023 screening test to be held on 7th January 2023 if it is not postponed. And I already posted yesterday that my earlier class video connecting number, if you just type that Mohammed Saheb Hussain-JCJ 2022 Civil and Criminal Rules of Practice online class 5/8/2022. Now, without wasting the time, let us go to the Civil Rules of Practice of Andhra Pradesh MCQ, that is the multiple choice questions as today. The first question, be ready. Which one is exact or correct sequence or order or writing of the today's online class? A. The Andhra Pradesh Civil Rules of Practice and Circular Order, 1990, full stop. B. The Andhra Pradesh Civil Rules of Practice and Circular Order of 1990. C. The Andhra Pradesh Civil Rules of Practice and Circular Order, of 1990. D. The Andhra Pradesh Civil Rules of Practice and Circular Orders, 1990. Which is the exact way of writing?
Option A, sir.
If you say option A, WRONG. I said exact way of writing, which is there on the heading of the 1990 Civil Rules of Practice. Shoot. Even though it is wrong, there is no negative marks.
Sir, option B.
WRONG. Hurry up.
Then option D, sir.
B, sir.
Option D is the right answer. The reason is A. The Andhra Pradesh Civil Rules of Practice and Circular Order, 1990 and full stop. There is a rule is there. Feedback I have given in the grammar rule or writing rule. Headings are usually single words or short phrases without a full stop at the ending. No punctuation in the heading. Headings and subheading does not have the different font and size. They have the same font, same size, bold, no punctuations, and the same rules are applicable as heading for the subheading also. Heading comes in the center of the page and subheading comes in the center of the page below the heading, and this I will show you like this here. The Andhra Pradesh Civil Rules of Practice and Circular Orders, 1990. There is no full stop. Is it clear?
Sir.
Yes, sir.
I appreciate. So this is the way of writing. So the exact way of writing also you should have know it, even though it is asked or not, but doesn't matter. But I would like to show to my students that they should be like Professor Hussain in both reading and understanding and giving the reply also. Okay, now second question. in exercise of its power under the article of the Constitution of India and the section of the Code of Civil Procedure 1908 dash has the promulgated the Andhra Pradesh Civil Rules of Practice, hereinafter called the Civil Rules within parentheses, the civil rules and regulate the practices and proceedings of all the courts subordinate to the apex court in the particular state. Now the option goes in this manner. A. Supreme Court. B. President. C. High Court. D. Governor. Which is the appropriate word in particular place? Mohammed Riazuddin, if you want to speak at the time, you can unmute it. Otherwise, you mute it. I could hear your sound also inside. Mohammed Riazuddin, yes, I appreciate. Yes, give me the answer. Which one is the appropriate in the dash? Either A, Supreme Court, B, President, C, High Court, or D, Governor. No silence. Silence will kill me.
Sir, Governor.
High Court, sir.
The right answer is High Court. Governor give the accent, but the rules are framed by the High Court. And those rules are implemented in the subordinate courts of that same High Court of the state. It's not the Supreme Court, not the President. President makes the central acts. And the governor makes the state acts consent or assent. Is it clear?
Yes, sir.
Now the supplementary question. The Andhra Pradesh civil rules practice, whether it is a central legislation or a state legislation.
State legislation,
It is
sir.
a state legislation. I appreciate. Third question. Anyone can unmute and read?
Who is the father of Civil Procedure Code 1877? A. Sir Arthur Cotton. B. Sir Arthur Hubhouse. C. Sir Arthur Willington. D. Sir Arthur Atkinson.
We cannot read the civil code practices or civil rule of practices without the civil procedure code. But earlier code name year is 1877, but that was repealed. The present code year, the present code
1908,
year,
sir.
civil procedure code
1908.
1908. Now you tell me 1877, who is the father of the civil procedure code, and he has taken a lot of efforts to make it. Did you see such a question any time before?
No, sir.
No, sir. I think Sir Arthur Atkinson.
WRONG. The right answer is option B. Sir Arthur Hubhouse. Later he became a lord, so Lord Hubhouse. Feedback. Sir Arthur Hubhouse later became the Lord Hubhouse, who was the then law member, made a substantial contribution to the draft bill with certain modification. The bill was enacted as the Code of Civil Procedure 1877. Is it clear?
Yes, sir.
Yes.
Generally, the court, they are asked the questions: who is the father of the IPC? Who is the father of the Civil Procedure Code? And once I told you also that what Whittaker stones, not stones, Stocking. I told, I don't know which act I told that thing. But try to remember as possible. But when the options are there, I'm sure that if you attended my class, you can shoot the right answer, even without having a knowledge to it, because the permutation combinations and equations, and you used it and you can shoot the right answer without knowing it. Okay, now the fourth question. The following rules and circular orders are issued under the authority of the High Court in the exercise of the power conferred by dash of the Constitution of India and dash of the Code of Civil Procedure 1908. Option A, Article 126 and Section 227, subsection 2. Option B, Article 227, subarticle 2 and section 124. Option C, Article 227, 1 and section 125. Option D, Article 227, 2, section 126. Which article has given such a power to make the rules to the state? Number 1.
Sir, option A.
Yes.
Option A, sir.
WRONG. Article 126 is the writs to the High Court.
No, sir. It's a it talk about central judiciary, sir. Central judiciary, like Supreme Court, like that, sir. Article
But,
140.
what I saw the answer is Article 227, 2 and section 126 of the Code of Civil Procedure. With that virtue of that article, the state is having the power to make the rules. Article 227, sometimes they don't write the subarticle 2, they write only 227 and section 126 of the Code of Civil Procedure. So that is the right answer. See, always you pick from the options which are given, which will be the very close to it. But if it is given Article 227 without writing the 2, and if it is given also Article 227 2, then you have to approach this one only, not 227. Is it clear?
Yes,
Is it
sir.
clear?
Yes, sir.
Sir, we don't know, sir. Fifth question. Anyone can unmute and read? I said anyone can unmute and read.
With previous approval of the Governor of Andhra Pradesh, the High Court of Andhra Pradesh hereby makes the following rules and circular orders for the guidance of subordinate civil courts in the state of Andhra Pradesh except dash. Option A, the small causes court. Option B, the minor causes court. Option C, the court of small causes. Option D, the simple causes court. Sir, option A.
WRONG.
Option C, sir.
C.
You have to speak the answer. Option C. The Court of Small Causes.
Small causes.
That is the appropriate word. No doubt, the Small Causes Court also gives the same. If you say, are you from your certificate is going to get from which university? Tell me, anyone?
Shatavahana University.
Can you say University of Shatavahanam?
No, sir.
No. Even can you say University of Kakatiya?
No, sir.
Can you say University of Usmania? Answer is no. Only Usmania University is there. Okay, now let us come to the sixth question. The civil rules of practice consist of how many chapters, dash, and how many rules, dash, and how many forms or form numbers, dash, are there in the civil rules of practice? Even I did not touch the volume. I did not touch the parts also because I also got confusion. So, A, Roman 20, 305, 76. Option B, Roman upper class is 21, 306, 77. Option C, Roman upper class 19, 305, 76. Option D, Roman 19, 306, 77. Chapters are represented by the uppercase Roman number, or we can say capital Roman. And rules are Arabic numbers. Even section also Arabic numerals or cardinals. Shoot! I think you did not see the civil code practices total. Here I have shown you. I drag it down. Of course, these are the forms. If you drag it down, forms are how many? 77. Then how many sections? See, I will drag it down. You can know that how many sections are there. How many sections? I mean, not section, rules.
306.
So now if I show you now which is the right answer? Which is the right answer? Sorry, you did not show the
Option B,
chapters. Sorry, you did not show the chapters, sir.
Sir, option D is
Option D.
306 rules and forms are 77. Is it clear? Read.
Yes, sir.
Repeat.
Sir, repeat.
I say repeat. I say repeat. Sorry, we don't know how to pronounce this. You don't know how to pronounce this. Option D. X means 10. Here 19 means you have to deduct 1. So from 10, when you deduct it, it becomes 9. So 19 chapters, 306 rules, 77 form numbers. Am I right?
Yes, sir.
How do you read this one? How do you read this one?
21 chapters, 306 sections, 77 forms.
Yes, I appreciate. Seventh question. What are the rules of the Code of Civil Procedure 1908? Section 43 dash passed by the civil courts in places in which this code does not extend. Section 44 execution of a decree passed by dash courts in places to which this code does not extend. Option A, execution of orders and revenue. Option B, execution of decree and civil. Option C, execution of order and land. Option D, execution of decrees and revenue. There are 2 dashes are there. Shoot, even though it is wrong. Silence will kill me. I told you, when the silence is there, what are my stanzas? My tongue is tied, my hands are handcuffed, my legs are fettered. Is it clear?
Sir, option A, execution of order and revenue.
WRONG.
Option B, sir.
Option D. Execution of a decree is there, not order.
Even
Execution is a decree.
revenue orders also called decree.
See, I don't know whether it is called the decree or not. My question is, in the revenue codes, it will not be applicable. That is my question. Is it clear? You have to
Sir,
go through
revenue
only
is
with
not
the
applicable.
options.
Sir, we call revenue orders, not decrees.
Okay. I asked here 4 options. In the 4 options, you have to choose which is the relevant one. Is it clear? There is no assumption, there is no presumptions. What actually the civil rule practice says, option D is the right answer. Shall I move further?
Yes, sir.
You have to choose from only the options, not assumptions, not presumptions. 8th question. Which option is mismatch? I say mismatch among the following. A. Section 212, mesne profits. 2. Section 2(9) judge. 3. Section 215 pleader. 4. Section 2(8) judgment. Here I have given the options. Option A 1 plus 2, option B 1 plus 3, option C 2 plus 3, option D 2 plus 4. In the definitions, rules, it is given. Actually, I should not say section here. We should say rules. Rule. Yes, now tell me. Which option is right option? Sir, we are checking the smartphone now. Then we'll give the answer. Don't do such a thing. Either you hunch it, or use your sense, or use your permutation combinations and shoot it. Yes, now. I say silence will kill me. There is no native mass.
Sir, option B.
WRONG.
So option A.
WRONG. I say mismatch.
Options C, sir.
See, what is the mismatch here I am giving you? What I made, 2(9) is judgment and 2(8) is judge. So I changed here. I changed this thing. So, which is mismatched? Which is mismatched?
2 plus 4, option D.
2 plus 4 is mismatched. Lakshmi, who's the advocate? Mute. I could hear your house dialects. Gaussian advocate, mute. Okay, now the 9th question. Match the following chapters from part A with the titles in part B. Part A, part B. 1. Chapter 3. 2. Chapter 4. 3. Chapter 6. 4. Chapter 7. In the part B, A. Affidavits. B. Advocates and recognized agent. C. Processes. D. Posting of cases. Options. A. 1B2C3D4A. B. 1B2A3D4C. C. 1A2C3B4D. D. 1C3B3D4A. I did not say mismatch. I say match. Silence will kill me. Shoot.
Sir, option B.
Read.
1B, 2A, 3D, 4C.
Right. Option B is the right answer for the 9th question. 1B, 2A, 3D, 4C. Here I am showing. Chapter 3, Advocates and Recognized Agent. Chapter 4, Affidavits. Chapter 6, Posting of Cases. Chapter 7, Process. Is it clear? Say yes.
Sir. Yes, sir.
Good. Now it's the big one. I will read it. 10th question. Dash of the Andhra Pradesh Civil Rules of Practice and Circular Orders, which contemplates marking of document produced by the third parties, justice, equity, and good conscience, is incorporated in the rules framed under the statute that the Andhra Pradesh Building, Lease, Rent, and Eviction Control Act 1860. In the adjudicatory and or judicial amount of suspicion was decided in the case of. There is a rule is there, there is a case is there. Option A, Rule 114 and Leela Enterprise versus Kamar Sultana. B, Rule 115 and Keela Enterprises versus Kamar Sultana. C, Rule 114 Leela Enterprise versus Zahira Sultana. D, Rule 115 Leela Enterprise versus Kamar Sultana. Which one is the right option? I made the 2 dash. One is rule, another is case law. I will show you the here again. Now choose the option among the ABCD. The right answer is anyone? Rule 115 and Leela Enterprises versus Kamar Sultana, Kamar, Kamar Sultana. That is the appropriate answer. Is it clear?
Yes, sir.
Can I proceed?
Yes, sir.
Read the 11th question. I said read the 11th question.
Deals about blind or illiterate deponent, Andhra Pradesh Civil Rules of Practice Circular Order 1990. Option A, Rule 41. Option B, Rule 42. Option C, Rule 43. Option 4, Rule 43.
Not for option D. This is
Sir,
committed a
same,
mistake.
sir. C and D both are same, sir.
Which one?
Option C and option D.
Okay, now I will make it 44. Now you tell me.
Option C.
Option C is the right answer. Rule 43 deals about the blind and illiterate deponent. Andhra Pradesh Civil Rules of Practice Circular Order 1990s. Who is a deponent? A person who executes a document is said to be a deponent, like affidavit. Is it clear?
Yes. Yes, sir.
But why you are keeping quiet? 12th question. Rule 43 deals about the blind and illiterate deponent. Which statement is or are correct? And here I have given 1. When an affidavit is sworn or affirmed by any person who appears to the officer taking affidavit to the illiterate, blind, deaf, or unacquainted with the language in which the affidavit is written, the officer shall clarify that the affidavit was read, translated, or explained in his presence to the deponent. Number 2. And the deponent seems to understand it and made his signature or mark in the presence of the officer as the form number 15. Otherwise, the affidavit shall not be used in evidence. 3. Provided that where the deponent, due to the mental deformity or any other cause, is unable to sign or affix his mark on the affidavit, such affidavit may be received in evidence. 4. If the officer before whom the affidavit is subscribed certifies that the contents of the affidavit were read over and explained to the deponent and admitted by him to be correct. Now options. A. 1 plus 2, B. 1 plus 3, C. 1 plus 4, D. 2 plus 4.
Sir, option A 1 plus 4, option C 1 plus 4.
Wrong. See, I will clear it here. Number 1, there is no deaf. Is it clear?
Yes, sir.
That means that is wrong.
Yes.
Is it clear?
Yes, sir.
Okay, now let us see what is the right answer here is 2 plus 4 is the right answer. This is 2 is very much clear and 4 is very much clear. Then what is wrong here? Tell me. Provided that where the deponent due to mental deformity or any other cause is unable to sign or affix his mark on the affidavit, which such affidavit may be received in evidence. Here what I did know, There is no mental deformity. The mental deficiency is there, but there is a physical deformity. In the third statement, I removed the physical and I added the mental. There is a physical deformity is there, but mental deficiency is there. Is it clear?
Yes, sir.
Can you say a girl, a handsome girl? Can you say? I said, can we say a handsome girl? Give me the answer.
No, sir.
What do you have to say? Sir, I don't know.
A beautiful girl, sir.
Beautiful girl. Why you are taking so much time? Okay, 13th question. Rule 256 dash. In order to provide for the custody of the property which cannot be conveniently stored or kept in the courthouse, the district judge may appoint for any court or group of courts a person who shall furnish security in any form applicable to a government servant for an amount to be fixed in each case by the district judge. Who is that person under order Rule 256? A receiver. Option B, administrator. Option C, Nazir. Option D, curator. Participants, are you there? Sir, we are checking the
Yes,
smartphone.
sir. No, sir. They're not checking.
Use your
Curator, sir.
curator is the right answer. See, just logic you can use it. Receiver comes in the inheritance or succession. And administration in the probate it comes. Where there is a will, where there is no will, and especially for the law of succession, these words are there. The feminine gender for the administrator is administratrix. And the Nazir will come, Sharishtedar, Nazir, they are in the court. Of course, Nazir also having a hand in taking care of the seized property, but the actually rule says curator. Is it clear?
Yes, sir.
Good. 14th question. Match the following chapters from part A with the titles in part B. Part A, chapter, sir, you are giving the difficult task to us. 19. Chapter 10 plus 7, 17. Chapter 10 plus 6, 16. Chapter 10 plus 5, 15. So part B, caveat. B, legal aid to the indigent persons. C, copies and copyist establishment. And D, proceedings in the execution. Now I have given the options. A, 1C, 2B, 3D, 4A. B, 1B, 2D, 3A, 4C. C, 1B, 2A, 3D, 4C. D, 1A, 2B, 3C, 4A. Just use the logic. Yes. Which option is the right option? Silence will kill me. I will be suffocated. I will be throttled. I say shoot. Are you there, participants? Are you hearing my voice? Yes, you could hear my voice. I could know that my signals are coming. My voice signals are there.
Yes, sir. We are here.
Gausia, K, Mohammed Riazuddin, Monica, Lakshmi.
Yes,
Sir,
hearing,
option
sir.
C. Sir, option
Option
C.
C is the right answer. 1B, 2A, 3D, 4C. See the feedback. Chapter 19, legal aid to the indigent person. Chapter 17, caveat. Chapter 16, proceedings in execution. Chapter 16 is proceedings in execution. Chapter 15 is copies and copies establishment. Shall I proceed?
Yes, sir.
Good. 15th question. In chapter 10, it deals about the documents, but there is a is there, capital A, B is there, C is there, capital D is there. But I numbered it's 1, 2, 3, 4, 5. And small a, I made the title of the chapter, Return of Documents, Production of the Records, Copies of the Proceedings to be furnished by the parties to the each other, Inspection of Documents. So A in the part, I made in the part A, capital A, capital B, capital C, capital D. In part B, I made return of the documents, the title of it. So now you match it. A, 1C, 2B, 3D, 4A, B, 1A, 2C, 3B, 4D, C, 1B, 2A, 3D, 4C, D, 1D, 2C, 3B, 4A. As I match it, which is the A title under the chapters 10 documents.
Option D.
Option?
D for Delhi.
I appreciate. Then I can give a clap also. See, this is the way you have to develop it. Even though you don't know it, but you can shoot it. Feedback. A, inspection of document. B, copies of the proceedings to be furnished by the parties to the each other. C, production of the records. D, return of documents. See, even though you don't know the answer, I know it. Because the way I framed the question, you cannot see in other places. But I am giving you the technique of framing it. In X angle, in Y axis, in Z axis, and in the different modes and planes, by using my intelligentsia, by using my brain technology. So now the 6th question. In the case of a small cause suits, I quote, dash, I unquote, judgments will be required only in connected to A, just, B, clean, C, fair and square, D, fair. Which is the appropriate word here? I repeat the question. In the case of small cause suits, dash, judgments will be required only in contested suits. What is this dash? Is it a just? Is it a B, clean? Is it C, fair and square? And it is D, fair.
Sir, option C, fair and square.
I know that you definitely will make that. I know that fair and square generally, when you are writing the written statement, you use this terminology. And we wish the court should give dispose the case with the fair and square way. But actually the thing is, which is the right answer?
Option D is fair.
Option D is the fair. It is not the fair and square. So rule 42 and 2 note clearly say the wording they used is fair, not fair and square. Is it clear?
Yes, sir.
17th question. Rule 144 2. Every decree shall ordinarily be drawn up as expeditious as possible, and in any case within the dash days from the date, within dash week of the day on which judgment is pronounced. Option A, 10 and 1. Option B, 15 and 3. Option C, 15 and 1. Option D, 10 and 3. Just use the logic from the given options. And I'm sure that you can shoot it. I have the confidence. I'm sure that you will shoot it because logic just you apply it among the four.
Sir, option B. Sir, option B.
Option?
B. 15 days and 3 weeks.
No, wrong.
Option D, sir.
10 and
10 and
3.
3 days.
No, wrong. C is the right answer. It is the 15 days from the date within 1 week of the date on which the judgment is pronounced. C is the right answer. But anyway, it doesn't matter. At least you tried your level best. 18th question. Match the following rules from Part A and held or decided in the case title in the Part B. Part A, all the rules. Rule 22, Rule 129.3, Rule 63, Rule 32. In Part B, all the cases. Sri S. Sudarshan Rao and others, petitioners versus the Citizens Cooperative Society Limited. B. Kandukuri Pakiramma and versus Kandukuri Pyari and others. C. Uguruboina Prasad versus Poonam Srinivaslu. D. Pujari Narsaya versus Modam Sudhakar and others. Options. A. 1D, 2B, 3C, 4A. B. 1A, 2B, 3C, 4D. C. 1B, 2D, 3C, 4A. D. 1D, 2C, 3B, 4A. I will show you again. Part A and Part B. Options. A, B, C, D. Now you shoot. See again. Part A, Part B.
Pass, sir.
Yes, a little difficult, but it doesn't matter. You tried just make a hunch, no matter. Even though it's wrong, doesn't matter. Option D is the right answer. Rule 22, Pujari Narsaya versus Modam Sudhakar and others. Rule 129.3, Ogrubaina Prasad versus Kunam Srinivaslu. Rule 63, Kandukuri Pakirama versus Kandukuri Pyari and others. Rule 32, Sri Sudarshan Rao and another petitioner versus the Citizen Cooperative Society Limited. 19th question. Chapter 2 from the proceedings, Rule 8 from of plaints, etc. Which statement is false? I say, which statement is false? Number 1. All plaints, written statements, applications, affidavits, memorandum of appeal and other proceedings presented to the court shall be written, typewritten or printed fairly and legibly on stamped paper. Number 2. Or on substantial full-scape foliage paper with an outer margin of about 2 inches and an inner margin about the 1 inch wide, and separate sheets will be stitched together book-wise. 3. The writing or printing may be in both sides of the paper and numbers shall be expressed in words. I say, which statement is false? Here, number A, 1, option B, 1 plus 2, option C, 1 plus 3, option D, 1 plus 4. Of course, there is no 1 plus 4.
Sir, option C, 1 plus 3. 3 is wrong, sir.
I
1
could
plus
know
3.
how to make it out. 2 plus 3, I can write it here. Yes, try again, once again.
Option C, 1 plus 3.
WRONG.
3 wrong, sir.
See, I will give the answer. Don't worry. Here, all plaints, actually, I think I committed a mistake. I said, which statement is false? That is the actually thing. So, what you said?
Option C, 1 plus 3.
Not exactly. I will give the answer to you. All parents' written statement, applications, affidavit, memorandum of special, and other proceeding presented to the court shall be written, typewritten, or printed fairly and legibly on stamped paper. There is no mistake at all. Now I'll read the second. Or on substantial full scale, foliage. Foliage is the leaf. Folio is the paper. I changed from folio to foliage. Foliage comes to it's a stem and leaves. Folio comes to the binding. 2 papers folio is equal to 4 pages. With an outer margin, here I committed it. Wrong. Okay, this is wrong. Okay. So now, in the writing or printing, maybe the both side of the paper and number. Here, paper, no. It is a sheet of paper.
So
Both
option D,
sides
2
of
plus,
the
option D, 2
represented
plus
leaves and flowers, once from 2 leaves, and there I said folios, sheet of papers. I say side of papers, not sides of the paper. It is a sheet of a paper, and a number shall be expressed in words. But I don't know whether words are there or figures are there. It is not words, it is figures. It is not the words, it is the figures. How do you number it? Do you number words or do you number figures? I say, how do you number it? Sir, first we don't know what is figure, what is words. You don't know what is words and what is figures. Say yes.
One is figure, FIRST is word.
Then what is figure? Arabic number, cardinal number. Is it clear?
Yes, sir.
So here 2 and 3 is wrong. False statement. Means
Option D, 2 plus 3
option D is the false statement. There is no foliage paper. There is a folio. And there is no words. It is a figures. Is it clear? Here, there is no words. There should be a figure. I will show you here. I committed what I said. See here, I already written. It should be a figure and not words. Is it clear? Say yes.
Yes, sir. Yes.
Good. 20th question. Rule 32, which one is the correct option? Number 1, when a party appears by any agent other than advocate, the agent shall, before making of or doing any appearance, application or act in or to the court, file the court the power of attorney. 2, or written authority thereunto authorizing him or a properly authenticated copy thereof together with an affidavit that said authority is still subsisting. 3, or in the case of agent carrying on a trade or a business on behalf of the party without a written authority, an affidavit stating the residence of this principal, the trade or business carried out by the agent on his behalf and principal. 4, the trade or business carried on by the agent on this behalf and the connection of the same with the subject matter of the suit, and that no other agent is expressly authorized to make or do such appearance, application or act. And here I made the options. I made the 1, 2, 3, 4 statement. I made the options here. A, 1 plus 2. B, 1 plus 2 plus 3. C, 1 plus 3 plus 4. D, 1 plus 2 plus 3 plus 4. Which is the correct option? See, these are the things. What is the question? Rule 32. Which one is the correct option? According to the rule 32. Because most of the cases are on the rule 32 and the rule 115. Should. Even though it is wrong, doesn't matter. Should. Sir, you are critically framed the question, sir. That's why we are getting fear to give. No matter, because there is no negative marks. And you shoot.
Sir,
at the time.
option
Yes.
C, 1 plus 3 plus 4.
WRONG. See here, I did not change anything. So the right answer is
Option D, 1 plus 2 plus 3 plus 4.
option D, one place, because all the places I changed it. I want to see whether they shoot it in a proper way or not. But anyway, doesn't matter, because here again I told you the thing. Rule 194, when stamps paper not available, it shall be open to the parties after obtaining the previous order of the judge on this behalf to furnish the white full-scape size paper of a durable quality with the requisite court fee stamps affixed on each dash in lieu of the stamp paper, and the paper so stamped shall for all the purposes be deemed to be the stamp paper. Option A, folio. Option B, sheet. Option C, paper. Option D, leaf. I am sure that you will make a mistake now. I am sure that you will make a mistake now. Because there I say foliage and I here say folio. If you say folio, WRONG. Because I told you what is folio. If 2 folios leaves, it becomes 4 pages. See, I gave the answer also. So appropriate word is see, I gave the hint to you. Wrong, folio is wrong. Next.
Paper, sir. Option C.
Next.
Option D, sir.
Option B is the correct answer. See, it is an open challenge if you could see such a thing in any one of the book which is sold in the market. I am not boasting my own pipe. It is the open reality. Do you agree with me?
Yes, sir.
It is each sheet in lieu of the stamp paper. Not paper, not leaf, not folio. 22nd question. The Land Council had drawn by attention to Rule 55 and Rule 218 of the AP Civil Rules of Practice, and also had a written May attention to order Rule 1, Rule 11 of the CPC, and contended that the relief of recovery of money cannot be prayed for, and in this view of the matter, the very EP containing the 2 prayers is not maintainable. Hence, the order of the delivery made in pursuance of such a execution petition is unsustainable in the law was discussed in the case of A. Viraya Perraju versus Pilli Achanna. B. A. Ramesh versus Chintala Prabha and others. C. Salva Pantula, Sheshagiri Rao and versus Rebala Subbarami Reddy and others. D. Sayyid Ghulam Khadir Saheb and others versus minor Vishwanatha Yar. Among the A, B, C, D, which is the right answer? I will show you again. Read.
Option D.
Option B is the right answer. A. Ramesh versus Chintala Prabhu and another is the right answer for this. There it is decided. When the EP containing the 2 prayers is not maintainable, and hence the order of the delivery made in pursuance of the such execution petition is unsustainable in law, was discussed in the case of A. Ramesh versus Chintala Prabha and another case law. 23rd, match the following rules from Part A and held decided in the case title B. And here Rule 40, Rule 115, Rule 89 and Rule 59, 54 and 48. And B, Mir Firasat Ali Khan versus Sayyiduddin Zafar. B. G. Krishnamurthy versus Hemalata Chit Funds Private Limited, Warangal and others. C. M. Veerabhadra Rao versus Station. D. Leela Enterprises versus Kamar Sultana. Options: A. 1C, 2D, 3A, 4B. B. 1B, 2C, 3A, 4D. C. 1A, 2C, 3B, 4D. Which is the right answer? But one thing is very much clear. Leela Enterprises, Kamar Sultana is no more, because that rule is different. So you can easily eliminate it. That means, yes, sir, it is difficult to follow it. No, sir. Anyway, shoot, doesn't matter, because such questions you do it in the last hour. Don't do it in the first hour. I mean,
Sir,
last
option
day.
A.
Option A is the right answer. 1C, 2D, 3A, 4B. I don't know what method that you used it. Rule 40, Mr. Veerabhadra Rao versus Station. Rule 115, Leela Enterprise versus the Khabar Sultana. Rule 8 and 9, Mir Firsat Ali Khan versus Saiduddin Zafar. Rule 59, 54 and 48, G. Krishnamurthy versus Hemalata Chit Fund Private Limited, Warangal and others. 24th question.
In last year paper, I saw sir Hemanta Krishnamurthy Hemalata case.
See,
In
I
that way, I
did not
skip
see any paper at all. But I know some papers I already read. So if a question may be framed in that way. I read all the papers, then I found no, we can frame the question in this way also. See?
Only Hemalata and Warangal case is there, sir. In last year,
Okay,
sir,
okay.
you posted in today, no, sir.
Okay,
5th
okay.
August 2022 paper.
Yes,
I
yes.
saw Warangal case in that paper.
Very good, very good, very good. I appreciate it, I appreciate it. So it is a lesson, and it is a guidance, it is a hint to the each and everybody, those who participated in today's class. 24th question. Match the following form number from part A to the explanation or title from the part B. So I gave the part A form number 65, form number 64, form number 63. That is a 1, 2, 3, 4, 5, 4. And here A. Rule 117, attachment of the degree of another court. Rule 18, claim to attached property. And Rule 171, payment into the court of cash deposit. Rule 177, order of the attachment of the degree when both the degrees are in the same court. Options C are given is A. 1A, 2B, 3D, 4C. B. 1B, 2D, 3C, 4A. C. 1C, 2B, 3D, 4A. D. 1B, 2A, 3D, 4C. It is from the form numbers. I told you already there are 77 forms are there, if I not be mistaken. So each form goes with the rules. So which is the right option here? Anyway, you try your luck, because it is also a tough question, but you can use your permutation combinations and my techniques and come to the conclusion. I know that you cannot make it out unless you have some logic. Yes. Even though wrong doesn't matter, shoot.
Sir, option C, sir. 1C,
WRONG.
2B, 3D.
Next option. Option D is the right answer. 1B, 2A, 3D, 4C. Here form number 65, rule 18, form 64, rule 117, form 63, 117, orders of the attachment they have given again, and form 61, rule 171, payment to the court of the cash deposit. I don't know the rule, same attachment of the degree of another court, they have given the rule again here 177, order of the attachment of the degree when both the degrees are the same court. The two things are dealt in the same way. The last question is, read anyone and unmute and read. Last question. I say read.
All sales at court shall begin at dash, and the sale of any last not put up before 5 p.m. shall be adjourned to noon on the next court day. Option A, morning. Option B, noon. Option C, before noon.
Option D, afternoon. Which one is the appropriate answer here?
All sales at the shall be net, and the sale of any lost not put up for 5 p.m. shall be urgent on the next code today.
It is a clearly, if you just read it, you know the answer. If you read the question, you know the answer.
Sir, next day before noon.
See, if it is after 5 p.m., shall be adjourned to the noon on the next day. Code day. That means right answer is here is noon.
Okay, sir. Okay, sir.
See, here it is given, no. Just you see it. Any sale,
Yes, sir.
all
sir, it is
sales
just-
at the code shall begin at dash. Forget about dash now. And the sale of any lost are not put before the 5 p.m. Before 5 p.m., you cannot do it because at the time there is arguments are there. And shall be adjourned to noon on the next day. Quote means every time it is the noon only the wordings are there, then it will be undertaken. See here the noon is here. Next day noon. If you don't come today, dash, come tomorrow, noon. Means if you don't come today noon, come next day, tomorrow noon. Is it clear?
Yes, sir. Yes, sir.
So morning is not there, noon is the right answer. Feedback is which rule depicts this, there's a supplementary question. Which rule depicts these timings? Supplementary question. Just have scrolled, you might have seen is rule
261.
261 is the thing. And welcome to the aspirants of the both AP-JCJ-2023. Yes, now time is up. Is it time is up or still time is there? Yes, time is there, no doubt. Okay, welcome to the aspirants of the both AP-JCJ-2023 ST and All India Bar Examination 2023 virtual class on the 6th January 2023 from 10 p.m. to 10:50 p.m. Multiple choice questions on Indian Evidence Act 1872. This is for both of them, it is there. Is it clear?
Yes, sir.
Yes, so please ask them to join the class. What is the next class? What is the next class? What is the next class? I put it on the screen. I put it on the screen. Tomorrow class is participants, still it is there. You are there, I could see you. Are you hearing me? Why you are so silent? The next
Code
class
of
is, yes,
Code of Criminal Procedure, sir.
Code of Criminal Procedure is next class. I
No, sir.
posted
The
here
Juvenile
what?
Justice, Care and Protection of Children Act 2015.
I kept on the screen just to look at and read, and just your kimia. Kimia means silent. In Kiswahili, kimia means silent. So, Juvenile Justice within parenthesis Care and Protection of Children Act 2015 is tomorrow class. What is the timing of tomorrow class? What is the timing of tomorrow class? Sir, we don't know. I told already. Today is Monday. Up to Monday we are having the holiday. And tomorrow is a working day to us. And tomorrow when the working day doesn't matter. The class is as usual from 9 to
9:50 p.m.
9:50 p.m. In Tanzania at the time is 6:30 to 7:20 p.m. in Tanzania. because you are 2.5 hours ahead and you are 2.5 hours behind. Now the time is how much do you know? In Tanzania, 7:37. In India, 7 minutes
10.
past. Am I right?
Yes, sir.
Yes. So please inform to the other people that I am going to take on 6th January 2023 from 10 p.m. to 10:50 p.m. that multiple choice questions on the Indian Evidence Act 1872, which is for both of them. And the last class is there. And from the 7th January, I will start the All India Bar Examination 2023. Sir, don't you tide yourself, sir? Answer is, if I don't teach, I die. What is the answer? What is the answer?
We don't want yes chances.
Yes? Yes, please. Okay, those who are interested, they can join it from the All India Bar Examination and from the 7th onwards, January, and the timings also I posted. Again, I will post also the timings time to time and inform the All India Bar Examinations. Knowledge never dies. Knowledge will increase it and you will become fresh also in the legal sphere. That is what I want to say. Anything that you would like to ask? Sir, what barracks I should have to take in the examination? Answer is?
Sir, no, sir. Already you had told that. No book has to be taken.
Nothing should be taken to the examination hall. You will become a parasite and you will kill the time rather than you use your own technique, the permutation, combinations, logic, then shoot it. That is only the best way to deal the things. Yes, at any time it will be going to be closed automatically because the time is going to up, and rather I could stop it. Better it could, yes, time is up. No, still time is there. I don't know because today is Cisco Webex is very much kind enough to you today, class. But I will say, end of the meeting, Jai Hind. सारे जहां से अच्छा हिंदुस्तान हमारा जय हिंद।